Bienvenue à la 3e édition des procès fictifs de la GreenWeek. Les citoyens.
Welcome to this 3rd week of the mock trial. This is an opportunity for citizens to go to justice, to ask for repair and uphold their rights to a healthy environment. They want more environmental justice and zero tolerance in the face of pollution, and they want concrete measures. The European Commission, who is the guardian of the treaties, is the one that is going to conduct the inquiry regarding any infringement, any breaches to EU legislation. At the beginning of May, DG Environment had 466 breaches which were open in all of the countries for air, and with a team of 24 lawyers. The Commission is systematically looking at the systemic cases. Why systemic? Well, because it relies on national judges to look at individual cases. The national judge is the guarantor of the correct implementation of EU law closer to the citizen to ensure proper implementation of the law, specifically on site, and also to correct implementation.
Were organized by 5 universities this year: the Utrecht University, University Catholic de Lyon, Muenster University, Gothenburg University, and the University College Dublin. Today, students from the participating universities are sharing with you the outcome of their judgment and the main takeaways of those mock trials. The aim of this comparative session is to identify similarities but also differences into court proceedings, legal standing, and procedural rules and practice. It gives also a fair look at the way the judge reacts depending on the type of claims that is made. So now, let's focus a little bit on this case study about air quality. What is it about? We have an individual, Mr. Bocken or Madame de Mongeau, depending on the university. This claimant is living in a nice area, in an urban area. So he has a nice apartment, life is good, but air quality is pretty poor. So, after several years, he realized that in 2018, 2019, limit values are constantly exceeded in this area, be it NO2, PM10 or PM2.5. He is quite disappointed by the action taken at national level to lower the curve of this limit value and to put an end to the pollution. What does he do? He decides to go to the local authorities, can be the municipality or whatever, depending on the case, and asks for specific measure to be taken because he does not believe anymore into the power of the air quality plans that were put in place till now. What does he ask? Well, he asks for the closing of the motorway exit next to his apartment, and he also asks to prohibit the cars and the lorries with combustion engine that are older than 2014. That request is made, as I said, to the local authorities, but unfortunately is dismissed in his request. But then what happens? Well, he goes to the judge. He is fed up, he is disappointed, he is frustrated. He asks for air quality plans with efficient measures in it. He asks for the annulment of the refusal of the local authorities to take the specific measures he asked for. On the top of it, an NGO wants to join to the proceedings. The NGO is concerned for the quality of life of the people in the area, and more importantly, of the children, because there is a kindergarten in the place. The NGO considers that fundamental rights, human rights, are breached. The fundamental right for a healthy environment. The NGO also claims that the recommendations of the WHO should be respected with regard to air quality. Now, without any further ado, please let me introduce you to our first representative for Utrecht University, Maartje. Maartje, the floor is yours.
Thank you, Sarah, for the great introduction. My name is Maartje, and I'm honored to speak on behalf of Utrecht University. A little shout out to my lovely student colleagues with whom I participated in this Moot Court. I don't know if we can go to the second slide.
Yeah, we're looking at your presentation. Go on, Maartje.
I believe it's not working, but
Go on, Maartje. We're listening at you.
It just takes a while. Yeah. These are my lovely colleagues, student colleagues. But let's start with our first reaction to the final result of the court hearing, which was kind of disappointing. The court namely imposed on the administrative body a duty to state reasons. And as you can imagine, not really beneficial to either one of the parties. But I'll come back to this at the end. In the following minutes, I will highlight 5 points that stood out from the court hearing. And let's first begin with the competence and admissibility. The Aarhus criteria did not play a significant role. Overall, in the Netherlands, the question of interested party is quite easily met. And as for CAN, so the NGO, it is possible to attach to the claim of Bakken, but it shouldn't be merely a litigation foundation. The judge therefore explicitly asked whether it also undertook actual activities aside from litigating. So this was the first general point. The second point is rather short, but not less important. The directive has been implemented fully in Dutch law. So we refer to mostly Dutch law in this case. The third point, which is interesting, is generally the Dutch Administrative Court only takes the decision directed at an individual, not general norms, such as the case of the air quality plan. But the claimants explicitly asked the court to do an exceptional assessment. And in that case, the court has to make a decision on this. However, the court values the discretion of the administrative body in making policy and therefore is very reluctant in doing so. Doesn't, however, mean that the court never decides on the basis of exceptional assessment. It did, for example, as well in a quite recent case, but it obviously remains the question if such a change should be in the hands of the court rather than the government. In any case, the court cannot directly change the plans. It can only ask the bodies to do so. This brings us to the fourth point. Apart from the exceptional assessment, the court held that the requests for the specific measures, so the traffic decisions, must still directly and explicitly flow from the air quality plan. And according to the court, this was not the case. And therefore, no obligation can be derived from this air quality plan for specifically these measures. And as I mentioned earlier, reviewing general norms is not generally done by the administrative court. It oftentimes refers it back to the civil court. However, the civil court refers it sometimes back to the administrative court, so it's kind of a boomerang effect. And also interesting to note is that the judge accepted that the 2020 was an atypical year due to the COVID pandemic. So despite the fact that within this year, the limit did not specifically exceed the limit, you can see still a general trend that the thresholds of the PM10 were exceeding. And then we will move on to the fifth and last point, which relates to the claim that it would be contrary to international law, and specifically Articles 2 and 8 of the ECHR. And the court did not disregard the possibility of invoking these provisions in relation to the WHO standards. So a positive obligation can be derived from these non-binding WHO standards. However, there must exist a common understanding or sort of general consensus within the academic world. And this has not been made sufficiently plausible by both parties. However, the judge called on the defendant, so the state, to substantiate why there would not be a general consensus. So this brings us to the conclusion, which I already mentioned, a duty to state reasons or more specifically, a duty to investigate for alternatives that will prove that these requested specific measures are not the only measures available to decrease the emissions. And in practice, this will probably take a few months, and the whole process, starts again, probably. And I'll leave it for this for now. Thank you for listening, and I'll give the floor back to Sarah.
Thank you, Marcia. Very interesting. And then we're pretty much looking forward to the next judgment, no? Don't we? So now let me give the floor to Alessandra for the University Dublin College. Alessandra, we'll listen to you.
Thank you, Sarah, and good afternoon, everybody. My name is Alessandra, and on behalf of University College Dublin, I will now quickly give you an overview of our national proceedings. So now, first of all, I would like to show you all the participants in our moot. So we had 3 students forming the NGO team, 3 students forming the individual applicant team, and 4 in the government team. Each team had a mentor, and you can see them at the top of the screen together with our judge. I would like to acknowledge here that this was a big team effort, so I would like to thank all my fellow colleagues, our mentors, and in particular our judge, Professor James McDermott. Now, moving on, I will now quickly give you an overview of the 3 main issues arising in the case. So, first of all, the issue of legal standing. In Ireland, there is a sufficient interest threshold in order to prove legal standing. And if this was relatively easy to prove for our individual applicant, Boken, it was a bit more complicated for our NGO, Clean Air Ireland. And indeed, for the NGO, there were 2 issues that were addressed. So whether the NGO had legal standing to
participate to the case.
Yes, and whether the NGO had legal standing to rise a bit more Irish does not stand to a corporate body to minimal rights that they do not enjoy. Therefore, the NGO did rely on exceptions in the Irish jurisprudence, and in particular on exception that grant the NGO the possibility to vindicate personal rights for special categories of people, such as small children and the unborn, for the right to life. And so, notwithstanding the is concerned, the judge in the end grant legal standing to the NGO because this was a matter of broad public interest. So now, moving on to the breach of the law, there were 2 issues here: whether there was a breach of the EU Air Quality Directive and whether there was a breach of human rights obligations. In constructing their arguments, both applicants relied on the WHO recommendations, but the legal value of the recommendations was questioned by the judge, as we can hear from this video clip. And I'm going now to launch a video clip from our national proceedings.
One question. In terms of the WHO fact sheet, is that of any binding legal authority?
It's not of any binding legal authority, no. However, we believe that it is of binding scientific authority and that it should inform any policy decisions which are made in the implementation and execution of the regulations. Is that sufficient?
And unfortunately, that was not sufficient. And indeed, the judge finally decided to stick to legally binding regulations and found that there was no breach because the limit values of the pollutants under the directive were not exceeded. Now, concluding with the remedy sought, both applicants asked the court to update the air quality plans in order to introduce measures in line with the WHO recommendations. And from this video clip, you can hear how the authorities responded to that. And I will now launch the video clip.
As my co-counsel Patricia has explained, the values of PM10 and PM2.5 in South Dublin are within the limit values requirements under Directive 2008-50. Therefore, the government has no obligation to revise the air quality plans to comply with the WHO recommendations under Directive 2008/50. For the foregoing reasons, we respectfully request that the court find in favor of the respondents and set aside the case.
And indeed, the judge decided in favor of the respondent, and since no breach was found, no remedies were granted as a result. But the judge did clarify that if a breach had been established, then the court would have probably declared the plans unlawful rather than granting the specific measures requested. And I believe my time is up, so I will now conclude my presentation, and I thank you all for listening.
Thank you, Alessandra. Yes, indeed. Thanks a lot for this. This is pretty interesting with the link with the WHO scientific precedents in a way. So now we go to Gothenburg, and I have with me Alicia. Alicia, the floor is yours for Gothenburg University.
Thank you a lot, Sarah. I'll start right away. My name is Alicia Engstrand, and together with my esteemed colleagues at the Gothenburg University, we have completed the mock trials here. The following presentation will be, here I'll show you the...
No worries, go on, please.
Yes, so I'll now go through the outcome of our mock trials in this presentation. So our proceedings consisted of 2 appealed cases. The first one started with a letter sent from Bokken to the municipality. And after a process of appeals, this ended up in the Land and Environment Court in Vänersborg. Both Bokken and the NGO were part of the appeals. Now, for the second case, this started with Bocken's letter to the administrative board in Västra Götaland. Again, after a process of appeals with both Bokken and the NGO, this too ended up in the Land and Environment Court in Vänersborg. It's important to note here that we actually both handled both cases in the same proceedings, and this was for the sake of both clarity and efficiency. Now, one of the main questions that was raised during the proceedings was whether the appellants even had the right of appeal. The court did rule that both appeals were admissible, and this was on the grounds that the relevant statutes of the Environmental Code had indeed been met by both candidates. For the most interesting part of this presentation, the outcomes and some of the main takeaways, well, the outcome for us was actually that the court ruled in favor of the administrative board and the municipality and rejected all claims that were put forward by both Bokken and the NGO. Some interesting things that we took away from this were, firstly, that the Århus Convention played a huge role in enabling the NGO to appeal. Without it, they would not have been able to. Secondly, while the competent regulatory authority does indeed have the authority and an obligation to act and take measures to be within the threshold limits, it is very difficult for private people or indeed NGOs or other actors to find solid legal support in requiring changes to be made to their specific established air quality programs. And lastly, we also found that in order to have even a slight chance of a successful case, the appellant's case has to be very heavily backed by concrete evidence in order to be able to show not only that the EU's minimum requirements aren't being met, but also that the municipality has actually failed in its supervisory role. So we're very interested in seeing where this leads after today's case by the CJEU. With that, thank you so much for listening. And on behalf of everyone from Gothenburg, thanks for letting us participate in these proceedings.
Thank you, Alessia, and indeed, thank you for the whole Gothenburg team. It's quite impressive to see our differences we can have in the procedure itself. In this case, it's pretty obvious. And also, it makes me think that maybe you noticed, we have a court case that was just sentenced by the European Court of Justice against Germany. So here, a way of addressing air quality plans and their efficiency, surely through systemic action launched by the Commission. So now, it goes to Muenster University with Clara. and Matthias, but Clara, firstly, the floor is yours, and we are delighted to hear from you.
Thank you, Sarah. Good afternoon. I am Clara, and I'll present the judgment of the Administrative Court in Germany. So the first thing we did was separating this great team from Muenster into 4 groups, each team representing 1 participant of the case. We have 2 claimants, the individual person, Mr. Bocken, and the NGO, and they both take action against the district government and also against the city municipality. So we had 4 individual claims. First, we were discussing the standing of the claimants. The standing of Mr. Bocken was granted in both his lawsuits without further ado, but the standing of the NGO was not granted in the lawsuit against the city municipality. This was no problem because the national law already provides with the option for NGOs to take action against the district government, and so there was no lack of judicial protection for the NGO when its standing was denied in the second claim. What you can see here is a useful table that contains all the values for particulate matter concentration that we had to discuss. First, we had to sort out which of the values are legally binding and which are not. And starting with the ambitious WHO limit values that you cannot see, I'm afraid.
Never mind, I think you can go on. Never mind.
From the air quality plan, yes, you believe me, they are ambitious, but they were not considered legally binding. So moving on to the European Air Quality Directive and the German national law, for the PM 2.5 concentration, which is pictured in the upper table, there are 2 limit values, and the one is more ambitious, but it was exceeded, but it is not clear whether it is legally binding or not. So the less ambitious limit value was not exceeded, and however, we didn't really need all these PM 2.5 limit values for the success of the lawsuits because we had a high PM10 concentration, which is pictured in the table below. As you can see, the PM10 concentration was only too high in 2018 and 2019. The 2020 limit value was not breached. This is nice, but it is not enough from the claimant's point of view. Here, we could convince the court, though, that in the future, after the COVID pandemic, there will certainly be a breach of the limit values again, like in 2018 and 2019. You might have already heard the word rebound effect, describing what will probably happen. The COVID pandemic will end and the PM10 concentration will rise again. So normally, the administration can decide which measures are necessary to control the air quality. There's a wide discretion of the administration and a low judicial review from the court. But when the administration did not see the risk of the rebound effect after the pandemic, it made such a mistake. It stepped out of its discretion. And that is why the court could rule that new measures should be taken. So if the person steps out of the yellow circle, then the court can decide what needs to be done.
Yeah.
However, the court did not come to this result, and the specific measures did not need to be taken. And this is what would probably happen now if this would have been a real case. The administration, who had sent all their plans and measures to the court, has to deal with a long judgment, and that does not really say exactly what has to happen next. It is the administration now that has to think about what would be sufficient to prevent us from rebound effects and a rising concentration of PM10 concentration. Now I give the floor to the next speaker, and
Thank you, Clara. Thank you very much. I'm pretty sure that we will come back on certain of the points that you made, particularly the rebound effect. And I take this opportunity to inform you that if you want to see all documents, they are published on the website. So you can scroll down, find the cases, get really the little details you will be interested in. And I'm sure that our students will agree in sharing their PowerPoint presentation in case you would like to dig into this a little bit more. Thanks a lot. Well, now I turn to l'Université Catholique de Lyon with Elisa and Marc.
We are now giving the floor to Elisa from the University of Lyon. I believe you have a video to show us. Yes, I'm Elizabeth. I'm representing the Lyon University. We're showing you a short video. So 2 teams of lawyers and students and judges. And this is a mock trial on the environment. The case is a person who is opposed to the municipality in Lyon and is asking for some restriction to traffic to improve the quality of air here where he lives. There are 2 lawyers who specialize in environmental law. This is an exercise which is pretty complex, and it's part of the GreenWeek 2021. The whole procedure is interesting, and in particular presenting the argument and trying to convince other people that you are right on top of all the texts which exist. This Moot Court is extremely interesting, and it really makes me want to become a lawyer later. The purpose, says this lawyer, was to help the students prepare their statement of defense and argument. So the case is, can we ask a collective authority to adopt a general police measure to solve a personal problem, an individual problem, which is associated to a specific pathology. So it is generally good to have a professional taste of what it is to be a judge, a magistrate, a lawyer. This is a practical exercise, a moot court like this, and it shows that the law is alive, it can be implemented most of the time. And for the very first time, these students come to a legal audience, and they can also get a taste to see whether this is a profession for them. And this was the case this time.
Elisa, on vous écoute.
So Elisa, we are listening to you. So I will show you the main items of the moot court we did in Lyon. We had 3 different periods. First, we talked about the plan for the protection of the atmosphere. Actually, in 2020, because of the pandemic, the values, the limit values had not been exceeded. So the question was this really representative of the threshold not to be exceeded? Because we could ask whether the threshold in other circumstances could be exceeded, also because the probes are not situated everywhere at the same time. Number 2, we looked at Article 8 to the right to privacy of the CDH. The employee felt that she could no longer be free to live at home, and so the threshold of seriousness was to be quite higher, and so we had to look at the directive. Number 3, we looked at the power of the mayor, who has special powers. However, in order to implement police measures, they need to be proportionate to the risk. And Madame de Mongeau had asked to put a stop to traffic of cars, and it was disproportionate compared to the risk, and this is why her motion was rejected. We were able to have this full immersion in the legal world, which is something that we could never have had in theory. We understood the complexity and all the work that needed to be done, and what was at stake. We really had to conduct the same steps as true professionals, we had to find solutions. This gave us an outlook of what could be done during a real trial. And we were able to see how history, so the past and the future, is really decided by the court. At university, we saw that people found different solutions. This was interesting because despite of the existence and implementation of directives, there is still some differences in terms of implementation of the law in each of the member states, where each state has its own proceedings. So I have nothing else to add because you have really pointed out the conclusions and the key takeaways. Thank you very much, because obviously this is an enormous amount of work that you've done, thanks to your law professors and the judges who really got involved to provide accompaniment to help you grow into this immersion experience. And this means that the legal people of the DG Environment are working on this every day. So I have a lot of respect for them. Why don't you maybe join our teams one day here in Brussels? And I wish you a lot of success for your future career. This is the beginning of your studies. You still have some hurdles to overcome, but one day you will be main players in this legal world. I think that you paid a tribute to the judges and you were able to show what it is to live and work in the courtroom. I'm going to let you go for a while, and I'd like to come back to Mark and Lisa. I have another question for them, and I'd like to say this. So if Mrs. de Mongeau had relatively easy access to a judge and was able to demonstrate her standing, this was not the case for the NGO. So is it really the way it is in real life? Mark, can you tell us about environmental democracy? What is this about? Well, thank you very much, Sarah. I will be brief. I'm not going to give you a course on how to have access to legal proceedings and the court. This is a central matter because, of course, you can only act and get the proceedings going if you have access to the judge. But the rules of proceedings are different from one state to another. Of course, we have the Aarhus Convention and other European texts which put forward a certain harmonization by opening up the courtrooms in terms of the environmental law. One fundamental issue as far as France is concerned is a individual such as Madame de Mongeau. The judge has recognized, had granted standing to Madame de Mongeau, despite the fact she's an individual. She lives not far away from a well-trafficked road, and it is in her interest, her standing, to challenge the measures that have been put in place. So this is not too complex, and from the reality point of view, this really corresponds to the reality. As far as the NGO is concerned, the rule on standing is the same, but for an NGO, the rule on standing will depend on the object of the association of the NGO. What is the purpose? Do they talk about protection of the environment? Well, then they are not going to have too much trouble in getting legal standing. Some of the NGOs in France are recognized and therefore have this legal standing almost ipso facto. But if the association or NGO is not considered as admissible, if its request is not admissible, it's because the judge will check that the rules of procedures of the association have been provided and that the purpose is protection of the environment. In this particular case, the requesting party had not provided the rules of procedures of the association. This can be considered as an error during this trial. However, it is not that rare that we encounter such a problem. In order to have a trial, all the parties have to be active and they have to bring the arguments to the judge. It's not the judge who's going to look for the arguments. So it is the responsibilities of the various parties to bring the various elements to the courtroom. And in this particular case, it had no incidence on the solution because as long as one of the requesting parties, in this case, Madame Desmongeaux, had legal standing, and this was granted, then the request will be examined by the judge as a whole. Thank you. So, at the end of the day, if I understand you correctly, it's not to the judge to develop the case. It's up to the parties to demonstrate that they have all the criteria to be granted legal standing. Thank you very much. I would like to move to Andrew and Alessandra for the University College of Dublin. Andrew.
Due to COVID-related lockdowns, it is to be expected that for many member states, the air quality reports for 2020 will show compliance with the limit values. So, does it mean that it's hopeless to ask for a specific measure to a judge?
Thanks, Sarah. I think the short answer is that the applicant's position wasn't hopeless, but certainly it was difficult. The easiest way, I think, to consider the issues is to look at the fact pattern that we were each given. As the audience has heard, we were asked to consider two pollutants, PM2.5 and PM10. In respect of PM2.5, which you see on the screen just now, as you can see, emissions fell below the limit value set by the Air Quality Directive in each of the 3 years under consideration, albeit, as you've mentioned, emissions were low in 2020 because of the COVID effect. But the position in respect of PM2.5 wasn't totally hopeless. As you can see, the World Health Organization recommends a limit value that's significantly lower than the limits set in the directive. And it's possible to argue, and this came out well in the Dutch national moot as summarized by Marcia, that the WHO standard represents an international consensus and that this consensus can be used to inform the interpretation of rights under the European Convention on Human Rights, the so-called common ground method of interpretation, which is applied by the European Court of Human Rights and has been applied by the Dutch Supreme Court in the famous climate case Urgenda. So a litigant can argue, for example, you, the government, have infringed my right to life, for example, and that right needs to be interpreted in light of the WHO recommendations. Now, moving then to PM 2.5, the facts are particularly interesting. We see the government exceeding the limit values in 2018 and 2019, and then we see the COVID effect in 2020. Emissions fall below the limit value, but only because of the reduction in traffic caused by COVID, as the applicants argued. Now, in several national moots, the court took a very formalistic approach here and simply said, the government is in compliance in 2020, so there's no breach. But interestingly, this wasn't the case everywhere. As we've heard in the Netherlands, the court said 2020 was atypical, and the court found that there was a general trend of exceedances before this. And in Germany, the court found no exceedance of PM10 in 2020, but a risk of exceedance after the pandemic. And in those two cases, the courts were willing to fine for the applicants in different ways. Two concluding remarks then. First, I think we can see that timing is everything in litigation. And here the applicant's timing was effectively very bad, because 2020 is a bad year to be litigating air quality given the COVID effect. So that's the first point. And the second point is, and Alessandra touched on this, even where a national court can be persuaded to intervene, the remedies available in different jurisdictions may vary. For example, as Alessandra said, the Irish court indicated that had it been willing to intervene, it would only have considered a general type of order like quashing an unlawful plan, and it would not countenance the idea of ordering specific measures such as ordering the closure of a motorway exit on the ground that that would, according to the court, infringe on the separation of powers. Thank you very much.
Thank you, Andrew. Very clear. So you give us a little bit of hope and I would say the big advice to say, timing is everything when we're talking about law, or at least going to court. So talking about advice, it leads me to ask to University of Gothenburg, in particular to David, what would be your advice to those like Mr. Bocken in our case, would consider going to court in 2021 and ask the national judge for specific measures?
Yes, thank you very much. Well, linking to what Andrew's already told us, I would say that this is a really inauspicious time for taking such a matter to court, since limit values have in fact been kept recently. And at least the Swedish court would most likely put much weight on the fact that there is a binding standard which is being kept, at least at the moment. And to order measures on a more precautionary basis, addressing a problem that does not exist at the moment, is, I would say, not a likely outcome in Sweden. To base a claim on human rights is conceivable, in particular by referring to the European Convention on Human Rights, but then it would probably not be seen as a matter of enforcement of EU law. I think from a Swedish perspective also in this situation, however, the existence of binding standards would likely have a strong influence on the interpretation of the substantive content of those human rights and what kind of air pollution level would constitute a breach of the convention. So also here a violation will probably not be found in this case, I would say. But of course the propensity to base decisions on these kinds of rights arguments and how to interpret them and fill them with substance varies between member states. So the prospect of success is higher in some countries than in others. In a Swedish context, it might currently, in fact, be more strategic to leave the issue of air pollution and instead try to base a case on environmental noise standards. In general, noise limitations are fairly strict, and exceeding them can, in principle, trigger rather far-reaching measures. So although the closing of a motorway does not seem like a proportionate response, but perhaps restrictions relating to certain kinds of heavy lorries could be imagined based on noise standards. Thank you.
Well, thanks to you. It's a quite interesting alternative going through the standards about noise. Maybe something to give some ideas to those who are listening to us today. So thanks a lot to both of you. Now I go to University of Muenster with Clara and Matthias. Hello, Matthias. Please do me.
Bonjour. Thank you for giving me the floor. It's an honor to be here. I'm Matthias Keller. I'm an administrative judge, and I was on this very interesting panel. So Sarah?
Yeah, indeed. We are super happy to have you, Matthias, with us. And I have a specific question for you, and based on your experience. So, you know, compared to the first edition of the mock trials in GreenWeek, no team decided to proceed through preliminary ruling to question the court. Why that? And can you tell us about it? And was it so obvious? And particularly having in mind the use of the articles 13, 6, or 16, this depending on the type of pollutant we're talking about. And I have in mind, of course, the PM 2.5 in particular. So I would be happy to hear from you. Thanks, Matthias.
Yes, thank you for this interesting question. There's a very short and simple answer. For the German judges, the case was quite clear. And therefore, there was no need of preliminary reference. So how come? It relies a little bit on the logic of case deciding. The German court based its positive decision not so much on PM 2.5, but on PM 10. And as you all know, the world or the context, the legal word of PM 10 is quite clear. You have Article 16, Air Quality Directive. The Annex 11 is quite clear. Even the tiny daily limit value of 50 microgram and 35 days max is clear and, to my knowledge, very well transposed into German law. So the court found that, well, let's put it very simply here, there will be too much PM10 in the air for the future. And this one ground, so to say, is already enough to send back the files to the administration and make them think again on how future exceedances can be avoided by drafting a better plan. So as you heard from Clara, the Corona period does not produce significant data for future situations. We certainly do not want to live the rest of our lives like in 2020. Personally, I'm very optimistic on that because it was today that I got my second shot of vaccine.
Yeah,
Nevertheless, yes, nevertheless, PM 2.5, as we all know, is harmful for the human health. And we had a very subtle discussion and deliberation on limit values. That was not so easy. And the Annex 14 sets the relevant limit values. That, however, and even from January 1st, 2020, according to this deliberation of the German judges, there is still the limit value of 25 microgram and not 20, which is, and here I speak as a concerned citizen and not so much as a judge, which is really regrettable. So thank you for hearing me here. And once again, we were very happy to participate in this wonderful project for the Muenster team. It was the first time, and I hope it will not be the last time, and we'll have a face-to-face event in the future. Thank you, Sarah.
I hope so. Thanks so much, Matthias, and we hope the same. We hope to see you physically in presence, even if it's virtual, it's for real, hopefully, and it's a pleasure to be all together now. On this interpretation of law, I'm pretty sure we will hear about it again. It's not super evident, and that's also the purpose of this mock trial, to focus on these little footnotes and whatsoever that are in there. You know the position of the European Commission in that respect. There is clearly for us a binding limit value here. It's in 2013 that the requested review was, we proceeded with the requested review, so that we consider it to be binding. But okay, point taken for Germany today. I think the day is already pretty busy with hair cases and the NO2 in particular. And see you next time, surely. I hope also with a very good celebration even. So that leads me now to Utrecht University with Herman and Maartje. So Herman, the question is for you. The request to the court for specific measures, I mean, the closing of the motorway and the prohibition of cars and lorries with combustion engine of older than 2014, were both rejected in all mock trials. Hmm?
Yeah.
So,
yeah, right.
in your view, what kind of evidences should be brought to have better chances to prosper in a case where one would focus much more on the efficiency and the sufficiency of the air quality plans?
Yes, thank you, Sarah, for this question about proof and evidence, and actually the division of the burden of proof in air quality cases. Now, I think it was Andrew that raised some hope, but I think in that respect of the proof and evidence, I have some worrying conclusions, but let's start from the beginning. As you said, in all cases, the parties asked for concrete measures in order to improve the air quality, namely to close down the exit and of a local motorway and to ban certain types of traffic from a specific part of the city. The plaintiffs claimed that these measures, and only these measures, would be sufficient to meet the Directive's air quality standards, which were not met at the time and of the procedure and were not likely to be met in the near future. So, and this could be important from an evidentiary point of view. There was a clear violation of the air quality standards, so that's clear, but that's important. Now, as far as I understood and as you underscored just a moment ago, however, in none of these cases, these claims were granted. In the Netherlands, this was mainly because of the fact that plaintiffs could not prove that indeed only these measures would be effective. And I doubt whether this would have been possible at all. Now, in our court decision, this was taken care of, as Maartje just addressed, but this does not necessarily mean that these or other measures will be taken in the near future. So as Maartje has already clearly addressed, the plaintiffs in the Dutch case have instead also contested the lawfulness of the policy, the national air quality policy and the local air quality plans by virtue of exceptional review. In that respect, it is important to know that administrative courts in the Netherlands are not competent to judge the lawfulness of policies and regulations, but they have developed the instruments of exceptional review to be able to at least indirectly assess the binding effect of such non-appealable types of decisions of government legal acts. Now, in order to be successful in their claim, plaintiffs, I think, should have proven that, briefly said, no lawful decision-making could have taken place on the basis of these national and local plans because of the unlawfulness of these plans themselves. Well, that's quite a heavy burden. It's quite a heavy load. And in failing to do so, this was something that the court was not willing to accept. I think in order to contest the lawfulness of the national and the local air quality plans, the plaintiffs would have also chosen to start a procedure before the Dutch a civil court, as the civil court judge, the civil judge is competent to directly assess the lawfulness and policies of regulations. But this would have meant that plaintiffs would have entered into a so-called equal parties process, which would have been a clear disadvantage for them from an evidentiary point of view. In other words, this would have meant that they would have had the full burden of proof to prove any unlawful aspects in national or local air quality policies in order to have at least any chance of success. And in failing to do so, these plans, these policies would be seen as lawful in themselves. The civil courts, by the way, unlike the administrative court, have a rather passive passive position in this type of procedures. Thus, proving the unlawfulness of air quality policy has proven to be nearly impossible, at least in the Netherlands. And here I can refer to infamous precedents, such as the case law in case of the Stichting Adem or the Bread Foundation, freely translated, which has litigated for years in order to improve the air quality in the Utrecht region, where I'm from, in particular the Amsterdamse Straatweg, Amsterdam Streetway, where I have lived. where air quality doubtlessly exceeded the standards, the air quality standards by far, like in this case. This was about a decade ago, but it was a case without success, despite the efforts of the foundation to prove unlawfulness of local air quality plans. So this leads to rather disappointing and worrying conclusions. It's hard to it's hardly possible to prove that air quality policy is unlawful, even though air quality does not even come close to the desired standards. It proves to be hard to enforce the effective execution of plans as well, and likewise, it also seems to be fairly impossible to legally require additional measures. This, I think, that's mainly to do with the division of burden of proof and the procedural rules in the Netherlands regarding the provision of evidence. But I think this also has to do with the formulation and the structure of the directives themselves, which focus mostly on the availability of air quality plans and less on the execution thereof. So bluntly stated, in case of the exceedance of air quality standards, on the basis of the current law, a plan is what you're entitled to. So a plan is what you get. And I doubt whether judicial activism, like in the Urgena case, which was mentioned before, will be a way out. But that's a topic for further discussion, I think, in the debate of today, but also in court. So thank you for your attention.
Thanks to you, Arman. Thanks a lot to all of you. This was really very, very, very amazing experiment. And with regard to Utrecht, just to say a word, with regard to the jurisprudence coming from your country, with Uganda, with the Shale Oil judgment recently released, I'm sure we will continue to look at what you're doing. So thanks a million for the brilliant work you've done. C'est procès-fictif, nous...
This moot court make us think of the principles, the very key principles of EU law, legal standing of civil society, the concept of environmental democracy, interpretation which should be in uniform, efficacy of law and the role of the judge, and we're becoming aware of the fact that environment and its protection is of vital interest. All of these moot cases have shown us that the Commission action is concentrated on planned actions, on planned measures, but if we focus on one specific period, we might fall in the trap of a meteorological episode which is such that the limit values are respected without anything having changed. And this is important for the climate change and the quality of air. We're getting more and more interested in an action focused on a series of measures. So the question is the planning, the objectives, and to a certain extent, policies, are they sufficiently correct to achieve the objective which is sought? In this case, the law is not just an instrument to control and sanction, but it's also one to prevent and protect the environment. And this is why we felt that the session today with this mock trial gives a lot of satisfaction. This exercise was so useful, and I want to thank each and all of you for having brilliantly conducted this comparative study. Thank you, kudos to all of you, because you did this brilliantly and you paid a tribute to all the professionals, all the legal professionals who are working so hard to protect the environment, uphold the collective interest, and protect future generations. Thank you to all of you. All of your names are appearing on the website. On behalf of everyone, thank you. Thank you also to our technicians. Thank you to the organization of the GreenWeek for what they did to organize this day today, this session. And this is something that you can't see every day. Thank you.
you.